So welcome to this, the third in a series of webinars from the Garden Court Crime Team. The series is looking at the position of children in the criminal justice system with a particular emphasis on the challenges that are being posed by COVID-19. You will have been muted when you entered the Zoom meeting. We would ask that you remain on mute unless you are speaking. You will have an opportunity to ask the speakers questions at the end of the discussion. Please post your questions in the chat window so that those questions can be put to speakers at the end. The presentation slides will be circulated to all registered participants, and I need to let you know that the webinar is being recorded, and what this means that the audio and video of anyone who is speaking will be recorded, and this recording may be shared. No other audio, video or personal data will be recorded or shared. So if you don't speak, you won't be recorded. Today, we are very lucky to have Anya Lewis and Danielle Manson from Garden Court Chambers, who are going to speak to us about the implications of video link hearings on the effective participation of child defendants and how best to manage them. Anya is an exceptional criminal advocate who is regularly instructed in complex and sensitive cases, including those involving vulnerable defendants and witnesses. She has established a reputation for representing child defendants and was successful in one of the first cases before the Court of Appeal, where she raised arguments relating to racial disproportionality following the Lamy Review. Danielle Manson has a particular expertise in representing children and young people and is known for being extremely personable as well as technically and strategically astute. She sits on the Criminal Cases Review Commission Stakeholder Forum and the Justice Racial Disparity in the Youth Justice System Working Party. Anya is going to talk to us about the legal framework for video link hearings before the coronavirus pandemic, and Danielle is going to examine how the legal landscape has changed since COVID-19. And so I will turn now to Anya.
Thank you, Kate. There we go. And good morning, and thank you everyone for joining us as we discuss via a Zoom webinar the implications of video link hearings on the effective participation of child defendants. I am initially going to address you in relation to where we were before the current crisis, because it seems to us that the court reform programme and the government agenda prior to COVID-19, because of that agenda, the changes which are implemented now from necessity may in fact not go away after the crisis, and it's important that we're all alive to this fact. I will then go on to look at the very limited research that has been undertaken in relation to video link hearings and the impact of hearings may have on the effective participation in general and in particular on child defendants, before handing over to Danielle, who will look specifically at the Coronavirus Act 2020 in relation to the provisions in relation to video link hearings, and then together we'll look at a protocol for video link hearings with child defendants that has been drawn up principally by Kate, who's chairing, with some assistance by myself and Jo Cecil. Before I start, I thought it may be helpful to put the discussion in context, to go through with you briefly 3 recent experiences I have had of representing children on video links. The first was a PTPH in a murder case at the Bailey, where 5 defendants, 3 of them under 18, appeared by video link. The 3 child defendants were together in a room, the older 2 were separately. To a person, each child and young adult slouched, laughed, looked disinterested, and behaved totally inappropriately to the setting that they were in. None of the children or young people, when they then later appeared in court, presented themselves in the same way. My second experience does not reflect particularly well on myself, but is informative, so I'm just going to run through it. I was at Isleworth and asked to assist a colleague by covering his case representing a child defendant who was facing 3 different indictments at various courts. The hearing was mainly administrative, but at the outset, prosecution counsel indicated that a plea to simple possession would be acceptable in relation to the possession with intent to supply Class A indictment, which was clearly in his interest to plead to. I introduced myself to the child, explaining who I was and what was going on. There was some toing and froing throughout the afternoon, and it took some time to persuade him that he should clearly take the plea to the possession. He repeatedly kept asking me about speaking to his solicitor, and I explained that I'd spoken to her and she endorsed the advice. And he acted rather oddly throughout the afternoon, to the extent that after the hearing, I said to the solicitor, "Have you had him assessed? Is he okay?" And she said, "Well, yes, he's fine," and wasn't clear what problems that I detected. Move on 2 weeks, and I bumped into that same experienced child solicitor. And she said to me, "He didn't know who I was. He generally had consistent representation, and I was a new face. He wondered, was I perhaps working for the prosecution?" And despite the fact that I had clearly set out to him who I was and what my role was, I had completely overestimated his understanding of the system and what was going on. And the poor child had spent the afternoon thinking that a prosecution barrister was coming in and trying to tell him to plead to part of the indictment. And finally, to give some balance, I represent a very damaged and mentally unwell 14-year-old charged with very serious sexual assaults. He himself was alleged to be the victim of male rape. And he regularly appeared by video link at the youth court, where we eventually managed to obtain a hospital order rather than a conviction. And for him, it seemed to me that was entirely the right way for him to appear. It would have been stressful, disruptive, and served no purpose if he'd had to travel to court from where he was in Northampton. And so I move, used to the logistics of it, sorry. And so I moved to the first of my slides and looking at where video links started. Video links started at the turn of the century in 1999. Jack Straw, then Home Secretary, spoke about the success of the initial pilots and said that hearings were likely to become widespread. He hailed the development as a turning point in the modernisation of the criminal justice system. And according to a report on the BBC News in July 1999, the new system linking prisons to courts in Manchester, Swindon and Bristol was backed by 3/4 of defendants who'd taken part in the pilot. The one thing the news didn't report, but is contained within the same analysis of the same pilot, is that 83% of defence lawyers felt that the link was unfair in some respects. An evaluation of the scheme recommended expanding it, and the initiative was expanding the initiative as a way of cutting costs and improving security. Video links were initially intended to be used for case management and remand hearings, but over the years, their use has expanded to a greater range of hearings. And I've included on the slides, and the slides will be available to you after the hearings, the relevant statutory provisions. I don't intend to talk you through them, they're there on the screen, and as I say, you can have the slides afterwards. So they're the main provisions in the Crime and Disorder Act as amended in 2007, and there seemed to be a raft of amendments in 2007 to the relevant legislation. And there are the other relevant provisions set out on the second slide, and in particular, I highlight the Criminal Justice Act of 2003. Both the Crime and Disorder Act and the Criminal Justice Act of 2003 have temporarily been amended by the Coronavirus Act, and Danielle will deal with those amendments a little bit later in this talk. Moving on from the statutory provisions, I've got up on the screen some of the most relevant provisions from the criminal procedure rules. Once again, these have been temporarily amended. The amended version will be dealt with by Danielle. I'm dealing with the provisions as they were before the amendments and as they will be in theory once the temporary amendments stop. And you'll see there at 3.2.4 where appropriate live links are available, going down to 3.2.4b, only if the court is satisfied that the defendant can participate effectively by such means. And it's perhaps significant, as Danielle will come on to, that in the amendments, that key phrase, which is about the importance of a defendant being able to participate effectively, has come out of the criminal practice directions as they are now in their temporary format. And then continuing with the key amendments on this slide, and just at the bottom, to highlight another provision which has that phrase about the importance of the system ensuring the facilitating the participation of any person, and that provision there at 3.93 is still in force and so can still be relied on if you're making submissions about the importance of the court ensuring that everybody can properly and effectively participate. In addition to the practice directions, there is, in addition to the criminal procedure rules, sorry if I was saying practice directions, they were the criminal procedure rules. In addition to the criminal procedure rules, we have the practice directions. And as I understand it, this criminal practice direction in relation to the use of live links and telephone facilities hasn't been amended. They would clearly now have to be read in light of the subsequent amendments that have been made in light of the current crisis. And there we have, in terms of the general provisions, if I highlight 3M.5, there may be circumstances in which the court should not require the use of live link or telephone facilities. 3M.6, such circumstances will include any case in which the defendant's effective participation cannot be achieved by his or her attendance by such means. And perhaps most importantly, moving on to the next slide, youth defendants. There are specific provisions which deal with the position of youth defendants. They are important. I'm just going to read through them. In the youth court, or when a youth is appearing in the magistrates court or the Crown Court, it will usually be appropriate for the youth to be produced in person at court. This is to ensure that the court can engage properly with the youth and that the necessary level of engagement can be facilitated with the youth offending team worker, defence representative and/or appropriate adult. The court should deal with any application for use of a live link on a case-by-case basis after consultation with the parties and the youth offending team. There at 3M.14, it will rarely be appropriate for a youth to be sentenced over a live link. Then it sets out some circumstances in which it may be appropriate. And then 3M.15, particular importance, arrangements must be made in advance of any live link hearing to enable the youth offending worker to be at the secure establishment where the youth is in custody. In the event that such arrangements are not practicable, the youth offending worker must have sufficient access to the youth via the live link booth before and after the hearing. In addition to this guidance in the practice direction, there's guidance from the Youth Justice Board and the Magistrates Association, all of which recommend that children should usually be produced in person at court. In 2016, the Youth Justice Board issued a position on young people appearing in court via video link in response to concerns that had been raised that sentence hearings were taking place with young people over video links, despite the provisions in the practice direction. It is important to note that a digital by default approach to court hearings is not appropriate for children and young people. The YJB is concerned that there is a risk that young people will neither understand the gravity of their situation nor take the judicial system seriously if all of their interaction with courts and legal representatives is via video or telephone link. Having just gone through the practice direction, you may be forgiven for thinking that there were virtually no video hearings involving children pre-COVID-19. That, as you may realise, there is not our experience and not the experience of people responding to various surveys that have been done. All young offenders institutions now have prison video link facilities. The statutory provisions apply to children as they do to adults. No data is in fact kept on the number of virtual hearings involving children. And the Transform Justice Survey, which I'm going to go through in a little bit more detail a bit later, from October 2017, reported their use as prevalent. One has to put in the context of what is happening with video links, what then happened in 2016, where we had the launch of HMCTS reform and the court reform programme, launched in a joint statement from the Lord Chancellor, the Lord Chief Justice and the Senior President of the Tribunals. They said the revolution in technology will characterise tomorrow's justice system. In future, we intend to extend these benefits further by introducing a structured process of online pleading and by holding virtual hearings, enabling lawyers, parties and witnesses to participate in traditional hearings by telephone and video conferencing. Looking specifically at the position of criminal courts, we will invest in smarter, more streamlined processes to deliver better justice for all. And don't laugh, we want to ensure that the majority of Crown Court trials are heard on the day on which they are listed. The entire criminal justice system is being digitised. So this was the launch in 2016. There then followed the introduction in 2017 of the Prison and Courts Bill. This was abandoned due to the general election and hasn't been resurrected, I think because of Brexit and other priorities in terms of the legislative programme. And I don't have time to go through it in any detail in this talk now, but it is gives real insight into the ambitions of the government's programme, what they want to do, and the extent to which they wish to move our criminal justice system towards a virtual system rather than a system where we appear in person in court. And so, having been through that background, what are the implications of video link hearings on the effective participation of children? Given the ambitions of the court reform programme and the length of time we've now had video hearings, you may think that there would have been significant research undertaken by the government on its impact, and in particular you may think on the impact on children. There is recognition in a number of high-level reports, which I'll touch on in a moment, of the particular issues in relation to the effective participation of children in criminal proceedings. Added to the reality of a child defendant's developmental immaturity by virtue of the fact that they are children, you have the reality that a high proportion of children coming into contact with the criminal justice system have mental health, behavioural or learning difficulties and come from complex and chaotic family backgrounds. On the screen at the moment are some statistics from a review into advocacy in the youth courts commissioned by the BSB in 2017, and they're listing the characteristics of children who offend. 6 in 10 children in the youth justice system have communication disability. More than half of children in custody come from deprived households. 76% of children in custody have an absent father. 33% have an absent mother. A third of young boys and just over 60% of young girls in custody have spent time in local authority care. A third of children in custody have identified special educational needs. Approximately 30% of children who have persistent offending histories in custody have IQs of less than 70, signifying a learning disability, and between 65 and 75% of children in custody have suffered a traumatic brain injury. 31% of a sample of 13 to 18-year-old offenders in custody in the community were found to have mental health problems, compared to 10% of the wider population. I've then included on the slides reference to the 2 high-level reports that looked at the effectiveness of the youth courts and about the participation and ability of children to communicate. The first there is the Carlisle report from 2014, and the quote I've included there really sums up the statistics that I've just been through. And the second was the Charlie Taylor review from 2016, review of youth justice system in England and Wales. Despite the adaptations for children and for the best efforts of magistrates and judges, it is clear that the courts are simply not set up to ensure the full participation of children in criminal proceedings. Too often, children are alienated by the frequent use of opaque legal argument and arcane terminology. On many occasions, children leave court confused by the outcome and need to have it explained to them. So we have there highlighted for the government the real issues that exist already in terms of the ability of children to participate in proceedings. As I say, one might have then expected some proper research in relation to the impact of video links on them, but that simply hasn't been done. The first research in relation to video links and court proceedings was in relation to the pilot of the launch in April 1999. And I've already referred to some of the figures from that in my introductory, towards the beginning of the talk. That pilot did not include children. We then move on to 2010, where the Ministry of Justice published an evaluation of a virtual court pilot in Kent and London, where video link was introduced for defendants detained by police appearing in court from police stations. Once again, unfortunately, the pilot did not involve any children. The evaluation evidence found that the virtual court pilot in fact added cost to the delivery of criminal justice in the pilot area. Of most relevance to the issues we're looking at today was the response to the question posed, did virtual courts impact on judicial processes and outcomes? And highlighted in response to that were concerns that the physical separation of defendants and sometimes their solicitors in the courtroom raised concerns amongst practitioners. The fixed 15 minutes time slots resulted in time pressure, judged by some magistrates and district judges as risking delivering hasty justice. Some magistrates and district judges thought that the court had more difficulty in imposing its authority remotely and perceived that defendants took the process less seriously. And importantly there, the two matters highlighted at the bottom. The rate of guilty pleas and custodial sentences were higher in the pilot where there were video links, and the rate of defence representation was lower in the virtual courts. In terms of the implications, the report said this: the impact of the pilot on judicial process and the outcomes is complex. The evidence points to a series of factors that may be regarded as giving cause for concern, but the frequency with which they occur is very difficult to judge. If the virtual court concept is rolled out in future, it is recommended that these issues are further explored. I'm going to move now to look in a little detail at a report published by the Standing Committee for Youth Justice. They just don't understand what's happening or why, in April 2008. This report looked in detail at the responses which were specific to children in qualitative data gathered by Transform Justice through a Survey Monkey report. The Survey Monkey had over 180 responses and 8 in-depth telephone interviews were carried out. It found widespread agreement that the use of video links in terms of children has a negative impact on children's ability to participate in court proceedings because of the lack of communication and therefore understanding that video links afford a child. The evidence gathered outlined how video links exacerbated the problems which already exist in terms of children's ability to participate in court proceedings. And it went through a series of factors which had an impact. I'm just going to take you through those factors. Firstly, the practical difficulties with technology interfere with the ability of the court to communicate fully and effectively with a child defendant. Connectivity issues, time constraints, low quality audio and visual. Practical problems are intrinsic to appearing on video links. Children can only see certain parts of the court at a time. Those present will not have a clear view of the child's body language and non-verbal clues are lost, and discerning the size of the child is difficult. Organic conversations are not enabled, and there's no opportunity to ask a question or for clarification without interrupting the entire court. One yacht worker's response was, participation in hearings is more than just communicating. Being physically present when talked to or about makes it easier for the young person to ask questions if he or she does not understand, or to challenge what others are saying about them. Relationship with lawyer was a key issue, and the difficulties was a key issue that was raised in responses to the survey. Insufficient conference time was cited as a key issue. One conference lasting 50 minutes to explain the proceedings to a child is simply not enough. Children can often be frightened or mistrustful of court proceedings, and time is needed to build a relationship with their lawyer. The impact in terms of building relationships with people is likely to be especially felt in terms of BAME children who are already disproportionately represented in the youth justice system. The Lamy Review in 2017 expressly referred to the loss of trust in lawyers by BAME defendants. And I've put on the slide there, I'm sure everybody listening to this seminar will be familiar with the Lamy Review, but some key factors from the Lamy Review. Time with the youth offending team. Yacht workers who responded raised concerns over the lack of interaction between yacht staff and the child throughout the proceedings, with video link hearings offering no opportunity for a pre-hearing consultation, no opportunity for a post-hearing interview, and they're often unable to even see the yacht worker during the hearing. 80% of yacht workers who responded to Transform Justice's survey stated that video links made carrying out their duties, including their statutory duties, more difficult. No, not one yacht worker believed that video links made their work easier. And I've included on the screen there some quotes from the survey from yacht workers. If somebody appears via video link, either a standard hearing or a sentencing even, it's just a case of we're in the courtroom, but they might not be told we're there, they can't see us, they don't have any interaction with us at all. So really, for all intents and purposes, we don't have any role at all. Impact on support from families and carers. Over video link, the child is unlikely to be able to see their family or carer if they are present in court, let alone speak with them. A quote there again from a yacht worker: the child might be told that the family are there, but they wouldn't have any chance to interact and they wouldn't see them. So quite often we have parents saying, oh, I'm not going to bother coming then today, they won't know I'm there anyway. Failure to properly engage and suitably engage with the process. A child may not fully appreciate or understand the seriousness of the situation. A child's familiarity with technology can contribute to a child failing to appreciate the significance and consequence of their actions or the gravity of the situation. This, along with other factors identified, means that a child is often disengaged with the process and seems unaware of what is going on. It is perceived that if a child cannot understand what is happening, is generally disengaged with the process and may not appreciate the gravity, this may increase the incidence of difficult behaviour. This can also be strongly inferred by psychological evidence on children and brain development, whereby children are less likely to consider the longer-term impacts of a conviction, less capable of mature judgment, more impulsive, and lack consequential decision-making. And a comment there from a magistrate: children do not appreciate that they are in a court and not on a computer game. And lastly there, the difficulties of the system exacerbating communication and understanding difficulties for defendants who have vulnerabilities. It's often difficult to discern the physical or mental difficulties over video link. Very worrying that respondents to the survey felt that even when children have been assessed as having a vulnerability that may damage their ability to participate, this usually has no impact on whether they appear via video link or not. Respondents believe that the decision was determined by practicalities relating to travel, court space, time and budget, rather than consideration of the child's ability to understand and participate. And a quote there from a yacht worker: almost impossible. You can only see their face and there's little interaction. In my experience, unless you have time with the young person to prepare, it is very hard to tell the difference between a surly teenage behaviour, total lack of confidence, and or significant learning difficulties and a lack of understanding. People were asked to respond in the survey to the question, does the use of video link impact on court hearing outcomes? Some thought children were more likely to plead guilty, the majority felt the child was more likely to be refused bail, and some thought sentences over video link were more severe, which, as you'll recall, was the finding from the 2010 MOJ research that was done. The conclusions of the report by the Standing Committee of Youth Justice, having looked at the transformed justice data: virtual hearings compromise children's right to a fair trial, erode the support currently afforded to children in court, and prevent statutory duties from being met, particularly in relation to yacht workers. Such hearings may negatively affect outcomes. They threaten the development of reforms to youth justice. And the recommendations of the report: urgent review of the use of video links with children and the collation and monitoring of data, halting the expansion of video link hearings, and video link hearings should only be used in exceptional cases with appropriate adjustments. Coming towards the end, but just looking at a few more factors and reports before handing over to Danielle. The BSB in 2015 initiated a report in relation to advocacy in youth courts. And in terms of the findings that are relevant to communication issues, they found that the formality of court proceedings in language is a significant barrier to young defendants and witnesses' understanding and engagement with the process. And the point here that compliance masking understanding difficulties. And there's some quotes from the young people who responded to that review in 2015. think the bottom one was the one I wanted to highlight. All the people that were talking, I couldn't understand. They asked me if I understood. I just said, yeah. I just wanted to get it over with, and that I didn't want them to think I was being rude or something. There has been another significant piece of research that has been done. Researchers at Surrey and Sussex universities have completed a major evaluation of video-enabled justice. They observed and analysed hundreds of video link first appearances in Medway Magistrates Court to assess the impact on video on access to justice. This research, which my understanding is it is now being completed and would clearly be highly relevant at the moment in terms of what is inevitably having to happen at the moment, but it would appear that its publication is either being blocked by the Home Office or the Police and Crime Commissioner for Sussex. I think Jo Cecil thought that it was the Home Office that is blocking the publication of that research, and the fact that it's being blocked may be an indication of what it is contained within it. And finally, very recently, the Equality and Human Rights Commission published an interim evidence report on video hearings and their impact on effective participation. They identified that HMCTS reliance on defendants' self-identification of impairments is likely to lead to people's needs not being identified. You can't always rely on the person with an impairment to identify it. That video hearings can significantly impede communication and understanding for disabled people with certain impairments, such as learning disability, autism spectrum disorders, and mental health conditions. And you'll recall the statistics in terms of how many children are impacted by such issues. They recommended that the MOJ should commission independent research on video hearings with a primary focus on justice outcomes. The government's response to this in early March 2020, so just before lockdown, was that it does not propose to slow the growth in use of video links whilst it is being evaluated, and indicating that they were planning on proceeding full on with their court reform programme. And then, of course, we come to COVID-19 and the crisis that we're currently facing and the emergency legislation that's been drafted. And at that point, I'm going to stop sharing my screen and hand over for the moment to Danielle. Thank you.
Thanks, Anya. If you could just bear with me for a second, I'll just get my screen up and we'll make sure that everyone can see and hear me and what I'm saying. Yeah, great. Okay. So if I can just start by echoing everything that Anya's already said, and one of the primary reasons that we decided to do this talk was because actually we have grave concerns that these changes won't be temporary, and that there will be a significant push even after social distancing has ceased. I think there will be a greater push to get the backlog of cases that has obviously built up over the last 2 months through the court system. And I think what everyone here as practitioners needs to be aware of and cautious of is that we shouldn't be letting the need to be efficient trump justice ultimately. And that's really where I wanted to start. These provisions that are on the screen at the minute, so the Crime Disorder Act, the Criminal Justice Act, the Courts Act and the Mental Health Act have all had temporary modifications made to them by the Coronavirus Act 2020. The changes are already in force. They came in on the 25th of March. And the Coronavirus Act itself, and hence the modifications, are all subject to a sunset clause. So the changes are due to expire after a 2-year period. But of course, within that time, there would be scope for Parliament to pass primary legislation effectively maintaining those modifications, should it be felt that the changes have been good and positive. Obviously, that's not my opinion, but that is something that will probably be debated further down the line. The purpose of the amendments is to just generally extend the power that the court has to order a live link, and that can be audio or video. And so the general widening is that the circumstances in which a live link direction can be made have been opened up. There is now a provision for certain hearings to be conducted wholly by audio and wholly by video link. Defendants on bail are eligible to participate by live link, and there are also more scenarios in which a witness can give evidence by a live link. I've put on the slides, which will be circulated to you afterwards, where you can find the definitions of what we're going to be talking about: preliminary hearing, sentencing hearing. They're all defined in the Crime Disorder Act, and this concept of eligible criminal proceedings that are eligible for a live link direction, is contained within the Criminal Justice Act. And most of us know and appreciate what a live audio link is or a live video link is, but they're all defined as well. And they're defined identically in the Crime Disorder Act and the Criminal Justice Act. So if you need, you can find them there. Now, I've put together this rather colourful flowchart, which I hope will simplify what's happened. But in short, the court's power to make a live link direction in relation to the trial procedure, the court procedure, contained within the Crime Disorder Act and the Criminal Justice Act. So ultimately, the test that has to be applied is the same for whatever proceeding we're looking at: preliminary hearings, sentencing hearings, or the new eligible criminal proceedings. But the route to which we get there is slightly different. Preliminary hearings and sentencing hearings are what they say on the tin. Eligible criminal proceedings it's quite broad, includes summary trials, criminal appeals to the Crown Court, trials on indictment, and then any other trial in the Crown Court. And you can see there the specific provisions where they're all detailed in blue. Now, ultimately, when the court's deciding whether to exercise its power that it's now been given pursuant to the Coronavirus Act to order a live link, they have to have regard to the following points, which are in the large yellow box at the bottom. And so different considerations in relation to a witness and then any other participant, but I suppose sensibly considerations in relation to a witness, the importance of the witness's evidence, and then whether any direction might inhibit any party from effectively testing the witness's evidence. And then in relation to a direction regarding any other participant, because these powers extend to any other participant, the questions for the court and us as practitioners are, what is the availability of the person? Is there a need for that person to attend in person? What are the views of that person? The suitability of the facilities at the place where the person would take part in the hearing. And so that really touches on access to the technology. I've heard anecdotal stories of people only having a mobile phone, not really having access to a computer. So they would sort of have to attend using their phone, which isn't really appropriate. And then the last question, whether or not the person will be able to take part effectively. And then ultimately the court has to ask themselves whether it's in the interest of justice for the person concerned to participate through a live video or a live audio link. Now, if I just take you to my next slide, can see here that the statutory changes that have been made also place limitations on when certain hearings can take place either by audio or by video link. And so preliminary hearings, evidence from the defendant can't be given over audio link, but a person other than the defendant might participate for the purpose of giving evidence if suitable arrangements can't be made. And also, I think I've cut the bottom of that off, but it should read that the parties agree. And that's something that I'll come back to, the parties agree concept, because it's something that is present throughout the Act and is something that could act as a safeguard. But obviously, this limitation is in respect of audio links only, and there isn't the parties agree condition in relation to the use of video link, which will have its own difficulties, although I think it's probably accepted that generally video link is better than audio link. In relation to sentencing hearings and hearings where a guilty plea is going to be entered, again, an outright prohibition on the defendant participating by audio link. So it's not just that they can't give evidence by audio link, but they can't participate by audio link. And then someone other than the defendant can only participate by an audio link if the only reason they're participating is to give evidence, and then the catch-all provisions that we've just had already. Suitable arrangements can't be made for the person to give evidence by video link, and all parties agree. So slightly more stringent limitations in relation to sentencing hearings. Now, in relation to eligible criminal proceedings, which are governed by the Criminal Justice Act, we have additional limitations here. And that is the first safeguard, that a direction can't be given in relation to any member of a jury. And that's why we're in the position where we know with some certainty that, as it stands, there will not be remote jury trials, because there's an out and outright prohibition on that contained within the legislation. And then again, as with the other types of hearings, the defendant can't give evidence over an audio link. In relation to eligible criminal proceedings, there is the power for the court to order that the proceedings are conducted wholly by either audio link or wholly by video link. And of course, in light of the current circumstances, that would be the experience of some of us already. Some of us have already had hearings where we are using Skype for Business and participating at court. The defendant is on the phone via the prison video link system, and sometimes the judge is also at home as well. But there are strict criteria or conditions that need to be met in order for proceedings to be conducted wholly by audio or wholly by video link. And here we have the new Schedule 3A to the Criminal Justice Act, which basically takes you through the circumstances or the types of hearings when proceedings could be wholly audio or wholly video. You can see some examples there in relation to wholly audio proceedings, if the proceedings are preliminary or incidental to a criminal appeal to the Crown Court, etc. But what is concerning, I was going to say interesting, it's not interesting, it's concerning, for me is condition G for section 2, which is the second white text box. Conduct of proceedings wholly as video proceedings. And this is basically granting the power for summary trials in the magistrates' court to be conducted wholly as video proceedings. And that is something that I'll come back to specifically in relation to youths. But in short, I think it's ambiguous at this stage as to whether that would apply to youth court trials. It may well be that that's the position. And if that were to be the position, then obviously we'd have to undertake a careful review of what was happening in those situations. Anya already touched on this, but just so you can see, the new criminal procedure rules, or the amendments that have been made, Anya already dealt with this, but clearly the court was previously obliged to consider whether or not the defendant could participate effectively through the use of the live link audio or video, and that's now just been removed from 3.2. And so, although it is contained as a consideration within the statute itself, it is still something that I think shows a watering down of the focus on the effective participation of a defendant in these proceedings, in criminal proceedings. So, safeguards, I touched on a few already, but the legislation provides that the parties plus any relevant youth offending team must be given the opportunity to make representations before a direction is made, and off the back of that, a hearing can be held to determine whether or not a live link direction should or shouldn't be made. If the court ultimately decides not to give a live link direction, particularly in relation to sentencing hearings or for eligible criminal proceedings, off the back of an application being made, then it must be stated in open court the reasons for not doing so. And from following through my flow chart, there are some restrictions that were quite clear there in relation specifically to the use of the audio link. So a defendant can't use the audio link for the purposes of giving evidence. I've already touched on that. There are also prohibitions on those who are not giving evidence using a live audio link. So that would include judge, magistrate, legal representative, etc. And then, as I said, there's this effectively catch-all provision that the parties should agree to the use of an audio link in this situation before the direction can be made. And again, in relation to summary proceedings conducted wholly by video link, so that was the condition G from the new Schedule 3A, that also requires an agreement by the parties. So some safeguards there. Now, in relation to general concerns that I've been able to identify, Anya's already taken us through what research there is available on the impact of a live link direction being made pre-COVID. And I think it's fair to say that there is limited research. When the Sussex research is made available, that of course is going to be incredibly important, but published research at the minute is limited. And as Anya's already said, there are very real concerns about the quality of evidence given by a witness who's appearing over a live link. And I don't think it's just the quality of evidence that we should be concerned about. It's also sort of welfare issues, particularly in relation to youths, but also across the board, because preliminary hearings, first appearances and sentencing hearings are all very significant stages in the trial process or in the criminal justice process if there isn't a trial. And that is something where being able to be with your client, being able to generate that rapport, being able to take regular breaks, etc., are really important. And all of that's effectively taken away when a video link or audio link direction is made. Also concerning is the potential for the provisions to remain after the emergency legislation has expired. And another concern really is that even now, even with the increased use of audio and video link hearings due to COVID-19, the data that's being captured by HMCTS doesn't appear to capture the detail that we would really need moving forward in order to be able to properly assess what is actually happening and what the impact is. And I understand that the number of hearings being conducted by video link is being recorded, but it doesn't seem to be noting what sort of hearings they are, whether or not it involved someone who is particularly vulnerable, and whether or not the parties who participated would say that that was a successful hearing. In addition to the reports that Anya has already taken you through, there was one further one that was put together by the NSPCC in February 2019. And I just draw your attention to it, in particular table 4 at the bottom. And this was questions that were asked to people that had participated in trials that formed part of this research. Now, really, I do feel quite strongly that if we are going to be seeing an increased use of live links, then we should be using this opportunity where obviously that there are difficulties because of social distancing, etc. So where we are being pushed to have more video hearings, more audio link hearings, this sort of data should be being collated. And a simple question: are you satisfied that young defendants are enabled to participate as effectively as young prosecution witnesses? Questions like that should be being asked at the conclusion of some of these proceedings, so that when COVID-19 has been managed and when we're entering the next phase, we as practitioners are able to better assess whether or not the use of live links and the use of audio links is appropriate, particularly in relation to children and young people. So in short, the implications of COVID-19 for trials, specifically in the youth court, if Condition G applies to youth court proceedings, and if youth court trials are to take place wholly remotely, we're going to be in a position where children are not able to communicate or participate effectively, where the success of the trial or the hearing is contingent on the patience of a judge or a magistrate. So when I say patience, I mean permitting regular breaks so that you as an advocate can come out of the main screen that you're in and have a private conference with your child to see if they are effectively engaging appropriately. Difficulty in building rapport over the link if you've never met a young person before. In relation to wholly remote youth court trials, I think it's very unlikely that any issues of disclosure would be able to be resolved on the day. Those of us who practice in the youth court know that it's not unusual to attend on the morning of trial and be handed a disc with CCTV on it or additional witness statements, etc. And so unless and until the Crown are in a position to ensure that all the disclosure obligations have been met before the day of trial, it would seem pointless to me to set up a wholly remote trial, because those issues of case management will not be able to be dealt with over a link. Obviously, connectivity difficulties, which will then in turn impact quality of evidence given by everyone involved. So in order for a witness or a defendant to give their best evidence, they have to feel comfortable and confident in the system that they're engaging with and taking part in. And if they are anxious perhaps about using new technology or speaking into a screen, then that will impact on the quality of the evidence. And then the last 2 points for wholly remote youth court trials: the child's perception of the proceedings, which Anya has already highlighted, them perhaps not taking them seriously, and then the court's perception of the child. You know, Anya's anecdote earlier about, you know, children being on the link, but being sort of slumped over, not really looking like they're engaging properly, is going to have a negative impact on how they are perceived by the court. And just taking a step back once more, even if we don't get to the stage where we're having wholly remote youth court trials, but if the use of the link is extended just for the defendant, for example, a lot of these issues are still going to be present. It doesn't necessarily matter that it's wholly remote or partially remote. If the child is remote from the proceedings that are impacting on them, then their engagement, I think, would suffer, and we'd have to seriously consider and look at their ability to participate. Thinking now in terms of recent proposals that have also been articulated about trying to press ahead with trials, but that are complying with social distancing guidelines. We all know when we do a trial, either in the youth court or in the Crown Court, that there are different protocols for where people sit, and having the child sitting next to you or behind you and not in the dark, it is very intentional, because as a system we recognise that it's very important to have that young person close by in order to assist them engage and to ensure that they're following everything that's taking place. If we have a socially distant trial, it would be the case that wouldn't be able to take place, and that the child would have to sit further away from their advocate, which I think ultimately undoes all the steps that were taken previously to ensure that young people and children, when they're in a courtroom, are allowed and permitted to sit next to their advocate. Now, in terms of the reality on the ground, in my experience and the experience of colleagues of mine, I'm not aware of any youth court trials that are taking place remotely at present, either wholly remotely or with the child being produced by a link. I'd be interested to hear, perhaps in the questions section, if anyone's got any different experience. But I noted that the chair of the Magistrates Court Association gave evidence yesterday to the Justice Select Committee, and he said then that at present there seems to be a policy decision, and they're being very, very careful about youths, was what he said. So perhaps that's a reason, but youth court matters, in my experience, are being adjourned off in relation to trials. As I've said, it's unclear to me on a reading of the legislation whether the condition G in the Schedule 3A, it would extend to proceedings in the youth court being conducted wholly remotely. But that's something I suppose we could argue on another day. But it seems to me very likely that it would be. And so whilst perhaps for policy reasons youth court trials are not being listed, the power is likely to be there already contained within the provisions. I'm certainly of the opinion, and I know that Anya and Kate share this view, that any proposal or any steer at the minute towards commencing youth court trials remotely ought to be opposed, for all the reasons that have already been outlined. Quite frankly, there just isn't enough known about the impact of the use of this technology to be able to say with any safety or surety that this is an appropriate thing to do for children. And first appearances and sentencing hearings continue to be taking place in relation to youth court matters. And that does remain a cause for concern, although it's appreciated that there are some reasons that sentencing hearings may need to go ahead sooner rather than later. So bringing my part to an end now, really, what are the remedies that are available to us as practitioners in terms of these changes to the legislations that might make some of us feel a little bit uncomfortable? Well, it's quite clear throughout the legislation that there should be opportunities made for parties to make their feelings known. That's something that the courts ought to have regard to. So if you do have a matter that has been listed where a direction's been given and you do have objections to that, then make them known. In relation to evidence over audio link, I think we need to consider carefully whether or not, if we were in that position, we should be consenting to it. There may be some situations where you think it would be in a child's best interest for that to happen. I almost certainly cannot think of a scenario in which I would consent as a defence practitioner to proceedings being conducted wholly by video link. A trial, I'm talking about a youth court trial. I'm pretty certain on that, but that's obviously a matter for each individual practitioner. But again, the court requires the consent of the defence advocate, so that would be a matter for you. And then finally, and now handing back over to Anya, have regard to the child protocol in criminal cases, which has been drafted by Kate and Anya, and is going to be put on the screen now, I think, so that everyone can have a look at that. So Anya, I'll stop sharing my screen now, and then I think you
have to work out how to share mine again. Okay. Have I done that? Am I sharing my screen? No.
Not yet.
Sorry. Right. Screen. Sorry, a demonstration of the difficulties of video link hearings, the technology of doing this. Thank you very much for that, Danielle. And just to finish up, and I'm conscious of the time, Kate, with some input by myself and Jo Cecil, has drafted a child protocol in criminal cases, which is up on the Garden Court website. It has been updated, and the updated version, I think, was put up this morning. I've extracted from that protocol the issues that are relevant to live link hearings, and they are here on the video link. I don't know whether I need to read through it all or it's there in front of everyone, but it's essential that court hearings involving children should proceed safely, which may, it's recognised, require live link hearings during this period. There are a number of safeguards to consider if exceptionally a hearing involving a child defendant takes place over a, and that should say live link.
Anya, can I just interrupt you? Sorry. The screen that's showing for us is just the Garden Court slide in your documents.
Okay, I don't know why that is. My screen is showing the protocol. Sorry everyone, let's try it again. Share screen.
No.
No. Okay, Kate, do you have it available that you could share it on your screen? We practiced this. I don't know why it's not working. I'm obviously doing something wrong. I don't know what it is I'm doing wrong. Let me try again.
Anya, do you want me to try or? Oh.
Is this me again?
Yeah. That's better.
Is that getting through it?
Yeah. Well done.
No idea why that was happening, but we move through it again. And so there we have, as I've said, extracted from the policy the bits that are relevant to this, and starting to read there at little or big A on the page. we are inviting people to ask the judge or magistrate should state openly in the presence of the child, we note that there is evidence that children sentenced over video link are more likely to receive custodial sentences or be refused bail. We note that there are currently disproportionately high number of BAME children in custody, and this includes Gypsy, Traveller and Roma children. As a result, we have reviewed our decision to ensure no prejudice or bias has affected our ruling. B, there should be a member of the youth offending team present during the hearing, and the child should be aware of this, even if they're unable to see them. Ideally, they should be able to see them. There should be an opportunity for the yacht officer to speak with the child both before and after the hearing, with sufficient time for effective communication. And as I've highlighted earlier, the yacht team have specific statutory duties, and it is very important that the yacht team is able to fully participate and speak with the child. C, arrangements must be in place for the legal representative to communicate with the child both before and after the hearing, with sufficient time to do so effectively. Usual 15-minute time slot is unlikely to be adequate in the case of a child. D, a parent, guardian or other supporting adult should be present and able to participate in the remote hearing to support the child, including in the pre and post consultation with the legal rep where technology allows. E, it can be challenging for participants to follow what is happening during a remote hearing. Every effort should be made to facilitate the child's involvement in the hearing. Hearings must proceed slowly with appropriate pauses and breaks to enable the child to communicate with their legal representative if the need arises. And finally, an enhanced level of care should be taken to ensure that the language used during the hearing promotes the child's understanding, allowing them to participate meaningfully in the hearing. This is in addition to the usual steps taken to simplify language during criminal proceedings involving children. And so that's, as I say, the relevant parts of our protocol as they relate to live hearings. And I'm going to pass over to Kate now. There may be a little time for some questions if there are any. Thank you.
Thank you very much, both Anya and Danielle, for that really informative analysis of both the position in relation to the use of live links and audio links, in fact, before and after the changes to the legislation following the public health emergency created by the coronavirus pandemic. There is an opportunity for participants to post any questions they may have on the Zoom chat, and so please do that. In the meantime, I think it just might be interesting just to take a step through what we've heard this morning, and so perhaps Danielle, can I just clarify? So, is there nothing in the changes to both the legislation and the criminal procedure rules that addresses how parents and guardians will participate in hearings? And I'm thinking of the fact that under 16-year-olds must have a parent or guardian present, and that's something that would usually be facilitated for 16 and 17-year-olds.
As I understand it, obviously, if the child defendant was at home with the parent would be permitted to sit in with the child during that hearing. But I think the difficulty may arise if we've got children and young people in custody, for example. The Courts Act 2003 does provide the court with the power to order that the proceedings should be published effectively or recorded, and it might be that within that provision there's a way for parents to be provided with a link. The wording of the legislation is in relation to the Crime and Disorder Act and the Criminal Justice Act is in relation to a participant, and so it may be for those for those children who are under 16 where their parents have to attend, they would fall within the meaning of participant, and so they too could be provided with a link if they weren't in the same household as the child. But obviously there's that slight grey area where children are 16, 17, 18 and 16 and 17, and their parent isn't required, but obviously would be permitted under usual circumstances. So yeah, nothing specific, but my understanding is that if the court were to find that they were a participant, then they would be permitted to be provided with a link as well.
Thank you, because I think that's quite important. That's a clear distinction between adult defendants and children, that it's an important part of the hearing, that a parent is there to both participate and support the child during the hearing. And it feels like that hasn't been something that's been actively considered in these amendments to the legislation. And given the challenges that advocates have found in participating in these hearings that are currently taking place, that it's likely that parents are going to equally find challenges in doing so. I'm still waiting for some questions, and I think that your presentation has been so thorough that there aren't immediate questions coming from the participants. I thought it might be helpful just to mention that there will, I think, be situations where sentencing hearings, particularly where children have been waiting a very long time for their sentence to take place, where the defence advocate will consider it appropriate for that sentence hearing to take place over video link, even though there would be normally that would normally not be appropriate, but given that the likelihood that of the ongoing restrictions, but there is, we've mentioned in the earlier seminars, there's the interim case review guidance from the CPS, and so where you have got a child with an outstanding trial that has been postponed as a result of COVID-19, it may be worth making representations for that particular case to be being reviewed, because if we're saying if it's going to be a real challenge for them to be able to effectively participate, and Danielle, you've raised the challenges both if it would to happen remotely, but also even if it's going to happen with social distancing in court, for children to effectively participate where they may have to sit 2 meters from their lawyer could be a real challenge. And so I would encourage you to look at the interim case review guidance, because it specifically talks about children at paragraph 12, and it may be an opportunity to make representations. Anya, is there anything else that you wanted to bring in relation to that?
Oh, sorry, Kate, I keep messing with the screen. No, I've just been messaging you to say if nobody has any questions, then let's all go for an early lunch. If before we do that, can I, because Kate will be too shy to do it, I did have the screen up briefly. Kate is one of the authors of Youth Justice Law and Practice, which has all you need to know on youth justice law and practice. And there is a 20% discount voucher, which I think will be coming around after the seminar. So please consider going out and buying Kate's book. But if no one has any questions, then thank you all very much for tuning in. And I hope that was of some help to people or interest to people.
And yes, thank you very much, Anya. You will be receiving an email with the slides from today's presentation.
With the typos amended when it comes to you. So that if you want the slides, they'll be available to you, and a link to the recording. And I should let you know that next week, on the 12th of May, we will have the next in our series of seminars with Henry Blackstone, Lee Sargent and Audrey Mogan, talking about the national referral mechanism and the future for county lines children, reviewing the position there. So thank you very much to everyone for joining us today, and I'll bring this seminar to an end. Thank you.